Welcome students, welcome to iExamB and embrace the iExamB learning experience. Students, as you are aware that I have come up with around 8 parts of a series which I have started with respect to Companies Act 2013, that is the chapter wise revision. So this is the further part with respect to that particular series wherein I'll be going ahead and discussing the further chapter. Now, in case if you have missed to watch any of those parts of this particular series, you can go to the description of this particular video, जहाँ पे कि आपको link मिल जाएगा of the previous parts and you can watch them. Do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated. Now, moving ahead with our discussion, that is the chapter-wise revision of the Companies Act. So, in this particular video, I'll be going ahead and discussing the various important aspects that are there under Chapter 20 of the Companies Act, that is basically laying down the provisions with respect to the winding up. Winding up होता क्या है? In the very simple term, if we can actually understand, winding up is the coming to an end of the existence, the legal existence of the company. We have already seen that by way of incorporation, that is by way of law, the company comes into existence. क्योंकि कोई biological existence होता नहीं है, ये सारी चीजें हमने discuss की थी first part में. So obviously by way of law, by way of incorporation, the company gets its existence and it continues till the company comes to the very stage of winding up, which will be finally putting an end to the existence of the company. तो हम इसको कह सकते हैं वो process through which the life of the company that actually comes to an end, उसका जो भी assets है, properties है, that is basically used to pay off the debts, the liabilities, and जो भी surplus है, that will be distributed among the members. Now, this particular term winding up has also been defined under the Companies Act under Section 2 क्लॉज 94A. ठीक है, तो ये पर्टिकुलर सेक्शन जो है डिफाइन करता है इस पर्टिकुलर टर्म वाइंडिंग अप को एज यू कैन से द वाइंडिंग अप व्हिच हैज टू बी एज पर द कंपनीज एक्ट 2013 or it will be the liquidation as per the IBC. So that is the definition that has been provided with respect to winding up. अब जब भी आप वाइंडिंग अप पढ़ते होंगे, सुनते होंगे, आपके सामने एक टर्म आता होगा डिसोल्यूशन. सो व्हाट डज डिसोल्यूशन बेसिकली मीन? सो डिसोल्यूशन को हम कह सकते हैं वो पर्टिकुलर वे दैट बेसिकली लीड्स टू द कंप्लीट एंड ऑफ द कंपनी, द वे थ्रू विच company is completely dissolved and no further operations and all that can be carried on in the name of the company. So ये winding up और dissolution, क्या ये दोनों एक है? नहीं. Winding up is a prior stage, a pre-stage you can say, which is before the dissolution. So winding up is a pre-stage before the dissolution and dissolution is the final stage. Final stage of what? The coming to an end of the existence of the company. So, as I already mentioned, winding up क्या हुआ? Process of bringing the company's affairs to an end, जिसमें कि sell off होता है companies के assets, paying off the debts होता है, distribution होता है, जो भी remaining funds या assets हैं to the members, shareholders, etc., creditors. And if we talk about the dissolution, वो final stage हो गया in the very process of putting an end to the existence of the company, and it is after winding up process that dissolution occurs. Now there is a section 270 also under this particular chapter, which is basically laying down the provision that application of part 1 of chapter 20 that will be with respect to the winding up by the tribunal. So winding up process that can be taken ahead by the tribunal, which is the compulsory winding up. So the various provisions with respect to that have been dealt under part 1 is what section 270 is specifically laying down. If we move ahead with section 271, that is basically mentioning the various circumstances, the conditions in which the company may be wound up by the tribunal. So when can the tribunal go ahead with the winding up of the company? So if there is a special resolution of the members in that particular case, if say the company has acted against India, its sovereignty, security, etc., then in that case, then tribunal is of the opinion कि company के जो affairs हैं वो fraudulent manner में हो रहे हैं या company form ही हुई थी unlawful purpose के लिए या fraudulently and other things taking into consideration when the application is being made to the tribunal by the ROC, or it could be say any other person whom the central government will be authorizing for the same. Now, if there is a default in filing the financial statement and all, and that has been for 5 consecutive years, then that can also be a ground. And say if the tribunal is of the opinion that it is just and equitable to go ahead with the winding up, then also it can be taken ahead. So just and equitable, if we say with respect to the winding up, so basically the tribunal is of the opinion that it is fair and reasonable based on the various grounds, circumstances that the company should be wound up. For the 272 में क्या है, petition कौन फाइल कर सकता है वाइंडिंग अप के लिए, एप्लीकेशन कौन कर सकता है, तो कंपनी कर सकती है, बट वहां पे कंपनी को एंश्योर करना है कि कंपनी जो है अपने पेटिशन के साथ स्टेटमेंट ऑफ अफेयर्स भी सबमिट कर रही है. इट कुड बी बाय द contributories also that they can basically petition for winding up. The term contributories, if we talk about that, who are contributories? You can simply understand they are the ones who are liable to contribute towards the assets of the company when the company is going for the liquidation. So typically it will be involving the shareholders, members, etc. who are having any sort of financial interest in the company. Then either by the company or the contributory, or it could be both by the ROC. Okay, the application can be done. Then any person who is authorized by the central government and say by the central government or the state government if it is involving the interest of the state, etc. Further, there are certain powers which have been given to the tribunal for going ahead with the winding up of the company. Section 273 is basically providing for that. Now, if we talk about that, basically it is mentioning that once the petition is being received under section 272, then the tribunal will be going ahead and within 90 days, it can basically dismiss it with or without cost. That it can do. It can make interim order. It can appoint a provisional liquidator till the order of winding up. It can order the winding up. That would be with or without cost, or other orders it may give as it may consider appropriate. So once the petition is being received by the tribunal and the process can be taken ahead. Now the tribunal, if it is say satisfied with the petition or it cannot be satisfied or has any doubt and all. So in case if it is satisfied, it will be directing or ordering for the winding up and the company liquidator will be appointed. Say if it is not satisfied and all, it will be giving an order with respect to the investigation of the matter and a provisional liquidator will be appointed. So he'll be going ahead and investigating and reporting to the tribunal with respect to the affairs of the company. And in that case, final winding up order can be given by the tribunal. And in the other case, there could be the cancellation of the winding up. So in this way, the entire process can be commenced. Now, liquidator, who is he? You can simply understand it as a person who will be carrying out the winding up of the company. So the entire winding up process has to be carried out by a professional who is actually the liquidator. So he's the person who is appointed to take care of and to carry out the entire winding up process of the company. Now, the central government will be going ahead and appointing the official liquidator for the winding up. He can be the provisional liquidator or the company liquidator. So, investigation of the winding up, if it is there, which has been ordered by the tribunal, then the provisional liquidator will be appointed. If there is a winding up order being given, then the company liquidator will be appointed. Now, the entire process of appointment of the liquidator and all that will be taking place, and there will be certain terms and conditions with respect to his appointment and all that has to be taken care of in a procedural manner as per the Companies Act. Now, there will be intimation to the provisional liquidator or the company liquidator and the ROC. So, basically, once the tribunal goes ahead and passes an order with respect to the appointment of the provisional liquidator or if it is with respect to winding up of the company, then in a span of 7 days, it will be sending an intimation to the liquidator, the ROC, and once the ROC is basically receiving that particular intimation, it will be updating the company's records, publishing notice in the official gazette, and then if the company say it is a listed one, in that particular case, the stock exchange where the company's securities are listed, the ROC will be updating them, notifying them also. So once the intimation is being given to the ROC, the entire process will be accelerated and he'll be taking further steps with respect to the process. Now there is a winding up committee which will be formed. So company liquidator will be going ahead and he'll be making an application to the tribunal, and that he'll be doing within a period of 3 weeks from when? From the passing of the winding up order for the constitution of the winding up committee. Now this particular winding up committee, iski zarurat kya hai? Why it has to be basically formed, you can say. So it will be assisting and monitoring the winding up proceedings, okay, when the company liquidator will be going ahead and doing that. And if we talk about the committee, the composition, so it will be having official liquidator who is attached to the tribunal, nominee of the secured creditors, and professionals who will be nominated by the tribunal. So they will be a part of the winding up committee. Now the company liquidator will be going ahead and he will be facilitating the meeting and all of the winding up committee. And this particular committee will be overseeing the various liquidation aspects, you can say, that is taking control of the assets, selling the assets, checking audit reports, accounts, etc. All that will be basically taken care of. Now there has to be a monthly reporting to the tribunal that will be done by the company liquidator, and that will be including the minutes of the committee meetings. It has to be signed by all those members who are attending it, etc. So that has to be done. There will be a final report that will be drafted by the company liquidator for the winding up, and that needs the very approval or nodding of the committee also, the winding up committee. That particular final report has to be submitted by the company liquidator to the tribunal once it has been approved by the committee, and the tribunal then will be going ahead considering that particular report and passing an order with respect to the dissolution of the company. Now if we talk about the effects of winding up, so you can see the effect under section 278, 279 and 280. So the very effect we can see of the winding up process is that it is operating in favor of all the creditors and contributories. So basically the winding up order that is protecting their interest, you can say, that is of the creditors, the contributories, and it is ensuring that their rights and claims, they are being considered, they are being addressed during the entire winding up process. And that is basically treated as if they had jointly requested the winding up of the company. Section 279 is mentioning that all the suits and proceedings to start and continue only after the order of the tribunal. So basically, the permission from the tribunal for the new legal cases against the company after the winding up order has been given or provisional liquidator has been appointed is required. Any ongoing cases and all that also needs the tribunal's approval for continuing and all. Okay. So that is basically what has been laid down under this particular section. And then 280 is mentioning tribunal has jurisdiction to go ahead and entertain or dispose of any suit, claim or application or other matter related to winding up. So basically the tribunal has been empowered to handle a wide range of company related matters, whether it be the lawsuits and proceedings, claims, or be it any of those matters. The tribunal has been given the very authority that it will be ensuring that all the aspects of the company's winding up process and associated legal issues, they are being taken care of in a proper manner. Then there has to be the submission of report by the company liquidator. So report submission that has to be done by the liquidator to the tribunal and within a period of 60 days of the winding up order. That particular report which will be there, it will be including certain important aspects like the company's assets, liabilities, debts, etc. All the information or any other information which will be required by the tribunal, all that will be detailed in that particular report. Okay. And there might be certain additional details which are required. So that will be also covered in the report. Say, for example, how the company was formed, or if there was any suspected fraud, any recommendations that could be there with respect to maximizing the asset value, business viability and all, that all can be included as additional details. Then if we talk about the access to the report, then the creditors and shareholders, they are basically entitled to go ahead and inspect and obtain the copies of the report. Then there are certain directions of the tribunal that will be given based on the report of the company liquidator. So that directions, if we talk about that, you can see over here, that is basically time limit for winding up. So basically you can say the tribunal will be setting a time limit for the completion of the proceedings and dissolving the company. This particular time limit, you can say that may be revised if it is considered cost effective or if it is required and all. Then there will be order with respect to appointment of a sale committee. So the tribunal may go ahead and order the sale of the company as a going concern or its assets and all. So after considering the reports and hearing, you can say the relevant parties, it can go ahead and appoint a sale committee that will be doing what? Assisting the company liquidator in the entire process, okay, in the sale of the company assets, etc. Now, order for investigation if fraud is being reported. So, if any report with respect to fraud and all is there, then the tribunal can order an investigation, and based on the investigation report, it can basically take action, or it may direct the company liquidator to go ahead and file a criminal complaint against those who were involved in the fraud. Then other directions that will be including the order to protect, preserve or enhance the value of the assets of the company. And this sale committee which we just now saw over here, so who all will be comprising this particular sale committee is the creditors, the promoters and the officers will be there. Then the dissolution of the company by the tribunal. Okay, so the entire process of winding up will be taken ahead. Liquidation with respect to the assets of the company will take place, and then finally it will be leading to the dissolution. So once there is a completion of the winding up, the company liquidator will be applying to the tribunal that the company should be dissolved. In that particular case, what will happen that the tribunal will be going ahead and on that particular application, if it finds that it is just and equitable, it will be ordering the dissolution and the company will be considered to be dissolved from that particular date of order. So once the tribunal orders the dissolution, from that particular date, the company is dissolved. And within 30 days, tribunal and company liquidator will be sending the dissolution order, etc. to the registrar. So in this particular way, the entire existence of the company will be coming to an end. So with this, we come to an end of our discussion of this particular part. Do remember to take the practice test, which is the PDF which is attached to the description of this particular video. And in case if you have missed to watch the previous parts, you can go ahead and watch them. The link is in the description. And don't forget to subscribe to the channel and press on the bell icon so that you can stay tuned, stay updated, and make your preparations 50% faster with us at iExamB.